People versus Lance Robinet, file number 256862. Mr. Robinet, if you can come right to the podium there, please. If I could have counsel put your appearances on.
Director John Wicklow, Medical People. Larry Brown on behalf of Mr. Robinet.
Mr. Brown, can you tell me the status of this file today?
Yes, Your Honor. This is a two-count complaint for delivery of Suboxone as a habitual court offender. There has been an offer made in the matter, plead as charged for dismissal of the habitual enhancement. I have reviewed that with Mr. Robinet, and that is how we're going to proceed today.
Mr. Rolla, is that a correct statement of the plea offer?
It is, with restitution the same as well.
Mr. Robinet, have you had an adequate opportunity to speak with Mr. Brown about this agreement?
I have, Your Honor.
Is that how you wanted to proceed?
Yes, Your Honor.
You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Robinet, are you currently on any kind of probation or parole?
No, sir.
And you understand that by pleading guilty to each of these charges, which is delivery of Suboxone, that each of them carries with it a maximum possible penalty of up to 7 years and or a $10,000 fine.
Yes, sir.
With that in mind, what is your plea to each of those charges today?
Guilty, Your Honor.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all of those rights. You understand that you're giving up and waiving all of those rights by pleading guilty. Also, you don't have an automatic right to appeal the plea that you're making here today. You can only appeal by leave. That means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of that appeal. Do you understand that?
I do, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
It is not.
Are you pleading guilty because you are actually guilty of each of these crimes?
I am not.
So the date that I have is April 2nd of 2024. So over a year ago, does that sound like the correct date to you? On that date, were you here in Atchison County?
I was.
And while you were here in Atchison County, did you have some Suboxone?
I did.
And did you give or sell that substance to another person on at least 2 occasions?
I did.
Mr. Rolla, are the people satisfied with the factual basis?
Yes, Judge.
Mr. Brown?
Yes, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Brown?
I am not aware, and I also believe the court has complied with statute.
Mr. Rolla, do you find the court has complied with statute and court rule?
Yes, Judge.
Mr. Robinet, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter, excuse me, for a sentencing hearing. You'll be notified of the date and time of that hearing. It'll be probably about 30 days. In the meantime, are you going to meet with him?
Yes, Your Honor.
Here today? Okay. You're going to meet with Ms. LaFlesh here for, to set up a pre-sentence interview. And it's just important that you stay in touch with your attorney prior to that sentencing hearing. Do you have any questions at all?
Oh, not really, and I don't even know if this is gonna, so I have a construction business, and right now I'm under contract with 40 people. I don't, like I said, I don't know if there's anything. Is there any way you can push it out any further than 30 days? I just don't want, if something happened, if I was to go to jail, I want to make sure they get what they paid for, so, maybe take a month and a half to finish everything. I mean.
Mr. Rolla, do you have any objection to
No,
sentencing? Okay. So I can set the sentencing for 60 days out.
Thank you, Your Honor.
And then, so then it's going to be even more important given that like time that you stay in touch with Mr. Brown. so that you're able to review that pre-sentence report and be ready for that sentencing. Okay.
Absolutely.
Okay. Thank you.
Thank you very much.
All right, ma'am, are you Kimberly Hammond?
Yes, I am.
Okay, we're on the record in People versus Hammond. This is file number 256869. The record should reflect that Ms. Hammond is appearing today by video by prior approval of the court. If I could have counsel put your appearances on.
Record Judge approved that.
Larry Brown on behalf of Ms. Hammond.
Mr. Brown, can you tell me the status of this file today?
Yes, Your Honor. This is our first appearance in circuit court after the case was found over after a preliminary examination. I am going to request an adjournment in the matter. I am planning on filing a potentially dispositive motion.
Okay, how much time do you need to get that filed and set for hearing?
If I could have 60 days, that'd be great.
Mr. Rolla, do you have any objection to that time frame?
No, Judge, it simply indicate for the record as a plea offer, and was charged with possession of meth as a drug double and original offender. So the plea offer, then she comes to count one, the drug double and original offender would be dismissed. Obviously, if we proceed to court on a motion as indicated by the defense, those plea offers would be returned.
Mr. Brown, is there any reason why it's going to take 60 days?
It's just my caseload, Your Honor. I could prioritize this probably within 30 if that is better for the court.
I mean, what's the motion?
It is a search motion.
Okay,
It's probably going to be an evidentiary motion.
we're going to need evidentiary hearing.
I have some audio and some body camera footage, so I would probably need the officers.
Okay. Okay, so the time frame I'm going to set then is that it needs to be filed and heard within 60 days. So that way it's not. I just don't want to delay it any further. How much time do you think you would need for the testimonial part of it?
Probably more than an hour.
So when you get the date, just make sure that you specify to Jennifer that we need to set aside an hour for that, okay?
Yeah.
All right. So that motion to be filed and heard in the next 60 days, the court will set this for a plea hearing status conference at that 60-day mark. And Mr. Rolla, any dates that I can address for your side? So,
Okay, thank you.
Mr. Brown, any?
Just one more thing. I want to clarify, if we run it, and because I wasn't aware of this, but for my client's benefit here, if we run the motion, the plea will be rescinded, correct? Or if we-
I'm sorry, sir.
If we set and hear the motion, will the plea be rescinded?
If we have the motion hearing, the plea will be rescinded.
Okay. Thank you.
Okay. Ms. Hammond, have you been able to hear everything that we've said so far?
Pretty much, yeah.
Do you have any questions about how we're going to proceed with your case?
No, sir.
All right. So your next hearing may be a motion hearing. Mr. Brown will let you know what date is set for that. Otherwise, your next hearing in court will be in about 60 days. It's important that you stay in touch with your attorney between now and then, okay?
Okay.
All right. Thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
All right, let's talk about that. What we just watched was a pair of hearings presided over by Judge George Mertz. And if you like steady hands on the bench, he was exactly that: measured, professional, and flexible where it mattered. He didn't let things drag on, but also gave both defendants enough breathing room to be heard, which is what you want in a courtroom that could easily get bogged down in formality. First up was People v. Lance Robinet. And this one was pretty straightforward. Mr. Robinet came in facing a 2-count complaint, and the plea was worked out, plead as charged, but dropped the enhancement. Judge Mertz took him carefully through his rights, you know the routine: jury trial, presumption of innocence, cross-examination, silence, all of it, and Robinet answered in that clipped, almost subdued style defendants often have when they're just trying to get through the moment. He wasn't hostile, he wasn't evasive, but he also didn't come across as thrilled. The standout part was when the judge pressed on whether the plea was voluntary. Robinet initially said it is not, before quickly clarifying his intent probably. Nerves, but it was a noticeable stutter step. Once the plea was accepted, the judge set up the sentencing schedule, and Robinet surprised us with a little construction business subplot. He basically said, look, I've got 4 jobs under contract, and if I go inside too soon, those folks won't get what they paid for. You don't hear that every day. To Judge Mertz's credit, he didn't brush it off. He simply asked if the prosecution had an objection, and when there wasn't, he doubled the time frame to 60 days. Practical, fair, and humane, no drama. Just solving a problem. The attorneys, Mr. Brown for the defense and Mr. Rolla for the state, both did their jobs without any fireworks. Brown was steady and clear, walking his client through the deal, while Rolla confirmed the terms. Neither looked rattled. No grandstanding, just workmanlike lawyering. Then we moved to People v. Kimberly Hammond, where the dynamics were a little different. Hammond appeared by video with prior approval, and her case is still in the early stages. Defense counsel Brown asked for 60 days to prepare a motion, essentially a suppression argument around a search. The state, through Rolla, pointed out that there was a plea offer on the table, but it would disappear if the defense pressed forward with motions. The interesting bit here was how Judge Mertz handled the request. He wasn't keen on letting it drift endlessly, but he gave the defense the 60-day runway while making sure the schedule stayed tight file, and hear it within that window. No excuses. The balance between efficiency and due process was clear. Move it along. But don't rush the work. As for Hammond herself, she didn't say much, just confirmed she could hear, had no questions, and was okay with the plan. Her calm demeanor contrasted nicely with Robinet's slightly jittery presence. The whole exchange underscored how different cases feel depending on where they are procedurally, one at the plea stage, one at the motion stage, but both handled smoothly. Overall, the courtroom atmosphere was calm and businesslike, with small flashes of humanity, the construction contracts on one hand, the defense lawyers juggling caseload on the other. Judge Mertz kept everyone on track, the lawyers did their jobs without fuss, and the defendants got treated with patience and fairness. No yelling, no theatrics, just law in motion. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.